Oh, we have welcome everybody to AIB Radio County Assemblies, Jean Blaine and Maria Janet on the 30th of April 2011. Jean is our presenter. Go ahead, Jean.
Okay, I'm going to go. I think one of the most important aspects of these classes is the trust aspect, because I'm going to repeat some of this stuff but you need to get a foundational understanding of what's going on in the courtroom, because you want to remember that these judges and prosecutors are actors, and that's why you have to understand trust law and what's going on in the courtroom. Like I'm going to give you an example. I've been teaching tax law in regard to these mortgages, and that they didn't transfer the deed of trust and the promissory note to the REMIC. And I'm assuming everybody knows what a REMIC is. It's a trust fund. And most of these REMICs are Delaware corporations. What they do is they create a corporation, which they call it's a trust. And there's FACIDs, REMICs, SPEs, special purpose entities, and special purpose vehicles. And they incorporate these in Delaware because of the taxing structure there. They don't have to pay any taxes. Delaware is very lenient on taxes. They don't make them pay taxes, so they like that. That's why they incorporate there. They have more corporations incorporated in Delaware than anywhere in the world. Delaware's got more money than anybody on this planet. And it's because of the tax structuring they have there. So you have to understand, so what I did is one of my students has a couple that lives in Topeka, Kansas. And I'm telling you this so you can understand where these people are coming from. They called me up, and they're in bankruptcy court on a foreclosure case. And they wanted to know if I could help them. And they're going in, they own $1 million farm property, and it's in foreclosure. And they're in bankruptcy court, and they have to they're going to have a hearing. They have to sign a Chapter 12 agreement to put this property in Chapter 12 in order to get out of this. So I told them not to sign the papers, so they didn't do it. And I told them why. And so I did a letter. I wrote a letter to them. I drafted a 31-page letter and sent it to them. They read the letter, and they called their attorney and told them they weren't going to sign the agreement. And they said they wanted their attorney to talk to me. So the attorney calls me up and so I went into why they can't foreclose on this property. And the attorney, actually, he's one of the top attorneys in bankruptcy, and he agreed with what I was saying. But he says the judge is going to ignore it. Well, nobody's going to ignore what I bring up, especially since this is a tax liability, because this court doesn't have jurisdiction to foreclose on the property because the taxes haven't been paid. And so what happened, and he said that he recommended, and he says, I recommend that they sign this agreement and we go into a Chapter 12 on Tuesday. And I told them not to do that. And they told their attorney they weren't going to do it. And I told them, we're going to ask for a 30-day extension of time to do an adversarial complaint in bankruptcy. Bankruptcy is the only court where you can do an adversarial complaint. And so they told the attorney that they weren't going to do that. So I hung up, and the attorney apparently called Bank of America, who's the creditor in this case, the alleged creditor. And the attorneys and told them what I guess he told them what I told him. So the attorneys from Bank of America called these two people that I'm trying to help that are in bankruptcy court, and they told them, they said, what do you want? And they said, we want a release of lien and reconveyance. So they agreed to that. So they're going to sign an agreement to give them a release of lien and reconveyance of the property on Monday. I didn't even send them a letter. All I did was tell the attorney what was going on. They don't want this issue brought up in court because all the investors are liable. Reuters received a letter from the IRS in this regard. And the IRS told them that, and I have a copy of this letter if anybody wants it. And what it says is that the investors are liable for all these taxes. And the investors can sue the REMIC for the taxes if they want to. So they do not want this issue. This is what you call leveraging. And this is a very important issue. This is the only issue you should be bringing up in court. This is a tax issue. And the reason it's a tax issue is because the REMIC is a real estate investment trust. And they have to file a tax return. As soon as they acquire the property and they transfer it into the REMIC, they have to take the election to file a tax return and treat the property and the trust as a real estate investment trust. And in order to do that, they have to file a return, and they have to file a statement with the return with the district director in the area or district in which they're located. Well, they haven't done this. So number one is they violated Section 856 because they never took the election to treat the REMIC as a real estate investment trust. That's number one. And number two is they never took an election to treat the property as foreclosure property. They have to do that. Otherwise, it's a prohibited transaction. They cannot foreclose on property that hasn't been treated as foreclosure property by filing a tax return. Again, this goes to taxes. And the reason for this is you have to understand the reasoning behind this. Is because when they foreclose on property, they're doing a forfeiture. And all forfeitures are a tax issue. And why they're doing a forfeiture is because they never transferred the loan documents to the REMIC. They never hang on just a minute. Go ahead.
Remember, people, to put your questions in the question area so that Jean can answer the questions. I'm not seeing any questions on the board yet.
Well, let me call you back. I'm right in the middle of a class right now.
Oh, okay. All right.
Give me your number and I'll call you back. I got your check today. 763 458 5283. Okay, I'll call you back.
Okay, thank you.
You're welcome. So if they don't take an election to treat the property as foreclosure property, it's a prohibited transaction. And the reason for that is because when they foreclose on property, they're doing a forfeiture. The loan was in default at closing because they didn't transfer the loan documents to the REMIC. See, the funds for the loan come from the REMIC. So if there was no funds in the REMIC because they didn't transfer the loan documents, the loan was not funded. So the loan is in default at closing. And all these loans are in default at closing. That's number one. And they're unsecured. And the reason they're unsecured is that the deed of trust, which is the mortgage, was not transferred to the REMIC. So the mortgage is not in the REMIC, and the note, which represents the capital for the loan, is not in the REMIC. That's why you are a third-party beneficiary to the REMIC, and that's what that judge said in the Horace versus LaSalle National Bank case. He said the borrower was a third-party beneficiary. And beneficiaries are the mortgagee or the lender. What you did is you lent money through a negotiable instrument called a security to the REMIC. And the REMIC used that capital to fund all these loans. So you actually funded it. So that makes you have a defense in recoupment and set-off. And that's what Public Law 111-203 says. That was passed July 21st, 2010. It's on the internet. If anybody wants that, I will send it to you. I'll send all this stuff to Maria, and she can send it out to people. And this is 850 pages long. And it's in section 1413. If you read that, it tells you that you have a right to recoupment and set-off. That's because you provided the funds for the REMIC.
Jane, what's that document so I can remind you?
It's Public Law 111-203. It's Title 12, Section 5301. It's called the Dodd-Frank Wall Street Reform Act and Consumer Protection Act.
Okay.
This is in the reserves. You can't even they don't want people to find this out, see? Okay. Because of the ramifications of it. You're talking about, that means all the investors can sue the REMICs, and then they can go after the banks, and the banks would ultimately be responsible for it.
So can the beneficiaries sue as one of the investors?
Yeah, you are an investor. This is, if you go to Neil Garfield's website. I can send you one of my students sent me. This is an undisclosed investment contract. They violated TILA because they didn't disclose to you at closing that you were involved in an investment contract. That's a violation of TILA. And it's a violation of RESPA, Title 12, Section 2601 through 2609.
Isn't that in Neil's affidavit?
Yes. It's called the Real Estate Settlements Protection Act. That's what RESPA means. RE means real estate, P means protection, S means settlement, and A means act. So it's the Real Estate Settlement Protections Act. And they cannot make money off of mortgage loans. So what they've done is they induced you to sign a contract on the pretext that you were getting a mortgage loan so that they could get, and then they converted it it was already set up. They didn't convert it. They already had the investment contract in place, which is the pooling and servicing agreement. And they used you as the vehicle to create mortgage-backed securities, to securitize the collateral. Well, they never transferred the note and the deed of trust to the REMIC to securitize it. So all these investors bought unsecuritized securities, which are absolutely worthless. And all of these people know this. Nobody's ever brought this up in court. I'm the only one that's brought this up in court. And Neil Garfield is just finding out about this. Well, I found out about this 15 years ago. Okay. And I've been teaching it for 15 years.
Okay.
But I have all the documentation on this. So what they did is they did a loan modification at closing. It was an investment contract at its inception. It's not a mortgage loan, it's an investment contract because they have all four elements. You have capital, you have a return of capital through the managerial and entrepreneurial efforts of third parties, and you get a return on your investment. Those are the four elements of an investment contract.
Okay,
And
so
when they
all of
look at a security to determine whether it's an investment contract
so,
or a negotiable instrument, they look at the substance, not the form. In substance, it's an investment contract because of the maturity of the note. All these mortgage loans have a maturity of 30 years or more. Some of them have 20 years, but most of them are 30 years.
okay, so
That means that means that the note is a security, not a note, and
right,
that's
so let's slow down a little bit and come backwards a little bit here. So for those people that have lost their homes, they can actually go in and they would sue the REMIC on their situation or sue
yes,
the bank.
yes. You could. I think if you just write a letter, you could get your property back.
Just write a
If they don't
letter
want
letting.
this, you're talking about a total collapse of the whole banking system.
So if every person that's lost their homes wrote a letter to the bank that had their loan, or to whoever is trying to foreclose on them, or who did foreclose on them, or even the judge that signed the unlawful detainer against you, letting them know that you understand that what was done at closing was a loan modification because it was an undisclosed investment contract, violating this Title 12, Section 5301, and using Neil Garfield's affidavit as an exhibit, you should be able to say you are liable for these taxes that you never paid, and now I'm going to open this up and file suit against you. Or what would you do?
Yeah, you would sue them for the taxes. What I would do is file a 1099 file an 8281 and a 1099 OID. See, the reason you have to file, you got to read publication 1212.
Okay, you've got to go over 8281 because I have not. There's been several people that said they don't understand that.
Okay, what that does is it identifies you as the issuer. You were the, remember I went in this in prior classes.
But we didn't go over the 8281.
Well, yeah, but I laid the foundation for it by going into 4 Apple 104. You were the originator of the first funds transfer.
Okay,
And you were the issuer of the first payment order.
People are asking, how do I fill out the form?
Well, yeah, but before you fill the form out, you need to understand why you're the issuer.
Well,
you can't just start filling out paperwork until you understand why you're the issuer.
Because we gave the funds. We gave them the gift of the promissory note.
Okay, but I'm giving you the law that says that. That's what you need to learn, so that if they contest it, then you can say, well, I'm the drawer and the maker, and so therefore I'm the issuer of the first funds order or the first payment order. So therefore I have standing, I have a right to set off and recoupment under 3-305, and I have a possessionary right and a property right in the instrument and its proceeds, or its proceeds. If you want to go into the, let me see if I can go into that, but
yeah.
Anyway, what happened is the bank called him up. These people that are in foreclosure, they've never talked to them before. They called them up and asked them what they wanted. When have you ever seen a bank do that?
Well, that's what everybody wants to get to. And they're trying to figure out the process and the procedure to do that.
Well, I understand that, but you have to learn why. I don't want you doing something just because I tell you to do it. I want you to understand why you're doing this, so that if you get into if they start contesting, if they contest any of your paperwork, and a lot of times they do this to find out if you know what you're talking about.
Yeah.
So they, a lot of times they'll do that just to find out if you know what you're talking about. Well, this guy knows that I knew what I was talking about, so he told them. He called the attorneys, the opposing attorneys, and the opposing attorneys called them and asked them what they wanted. They said, we want a full reconveyance and release of lien, and they said they would do it. They're going to sign an agreement Monday. And I didn't even send them a letter. I just talked to I didn't talk to the Bank of America attorneys, but I talked to their attorneys, and he agreed with me. They don't want this issue brought up, and he tried to poo-poo it because that's the way attorneys are. If this ever gets out, you're going to have the whole banking system's going to collapse.
Yeah.
I'm telling you, you're talking about a total meltdown.
Is the court case, the Supreme Court case, this is a question, for the remedy for us to set off the debt, is it Guarantee Trust Company versus Henwood?
Yeah, well, that's part of it, yeah.
Or was it the Jenkins case?
That was HCR 192.
Okay.
Which is, it says that no contract or obligation shall contain a clause. That's part of it. That's why you're entitled to a recoupment or set-off. Because when they confiscate, you can't confiscate people's property without just compensation. That's the reasoning behind it. So what they're doing is they're confiscating your property. And they can't do that unless they compensate you. Well, the way they compensate you is they give you a recoupment or a set-off on your mortgage, but you're not raising the issue.
Does that go on?
You don't get it unless you raise the issue.
Does that go on everything, not just a mortgage?
Yeah, everything. Utility bills.
What about court orders?
Same thing.
Okay.
If it's a court order, if it calls for the payment of money, you got to have an amount on the bill.
Well, but most of your domestic forms don't have a final figure. They have $900 a month. Is that considered a bill?
What do you mean $900 a month?
Well, if you're talking about child support or maintenance or something like that.
That's a bill. If it has a dollar amount on it, it's a bill. And you do not have to, they don't have any right, it violates public policy for them to demand. I'm going to quote to you what HCR 192 says. It says, no contract or obligation shall contain a clause which purports to give the obligee the right to demand payment in any kind of specific coin or currency of the United States. So they're violating public policy by telling you that you have to pay in a specific kind of coin or currency of the United States. And that's what they're doing.
Okay.
Go read Hager versus Reclamation District, 109. It's on the internet. You need to get the case and read it.
Let's go say that again slowly. Hager
versus Reclamation District, 109. Here, I'll pull it up. And I've used this, and I've been successful every time I've used this.
Okay. And that says that they can't, it's HJR 192, right?
It goes in there. It tells you why they can't. It doesn't talk about this case has never been overturned. Here it is. You can download this off. It's 111 U.S. 107. Okay,
Okay.
and you can use this. Okay, read this first, this paragraph right here.
The acts of Congress making the notes of the United States a legal tender do not apply to involuntary contributions in the nature of taxes or assessments exacted under state laws, but only to debts in the strict sense of the term. That is, to obligations founded on contracts, express or implied, for the payment of money.
Okay, before you get into this, so you don't have a contract with the court. There's no contract in a mortgage. Let me ask you a question. Did the bank sign any of the loan documents?
No.
Well, then there's no contract between you and the lender.
Right.
So this is a tax issue, isn't it? What does it say? It says legal tender notes. In other words, you can't use Federal Reserve notes to pay taxes.
And that's
because
what they're
they're
asking.
involuntary contributions.
Right.
They're exacted under state law. And what you should do is get the judge's oath. He took an oath to uphold the Constitution. We'll bring up Article 1, Section 10. No state shall make anything but gold and silver coin a tender in payment of debts. Ask him. Say, is this a obligation founded on a contract for the payment of money? And he's going to say no. Then ask him. Say, is it an involuntary contribution in the nature of taxes or assessments exacted under state law? This case has never been overturned. So they can't demand that you pay. There's no debt, for instance.
So it doesn't matter if it's a parking ticket or a child support order or a mortgage situation, anything that has a dollar figure, it is all involuntary contracts exacted under state law.
Right. For the payment of taxes. And they can't make you pay it in legal tender. So what can they make you pay it in? They can only make you pay it in gold and silver, and there is none.
So that's really what everybody needs to go into their letter rogatory back to the trustee that's trying to sell the property on the courthouse steps.
Yeah, there wasn't they're not a bona fide purchaser for value. What does it say? When they do a sale on foreclosure sale on the courthouse steps, they have to tender either cash or they have to tender a check, a certified cashier's check. They never do that.
Okay, but that's still legal tender.
No, it's not.
I mean, it's not. Well, if they want you to give cash, that's legal. That's legal tender.
No, it isn't. Not under state law. What's legal tender under state law?
Negotiable instruments.
No. What does Article 1, Section 10 say is legal tender?
Gold and silver.
Right.
So, you know, when they sold my house on the courthouse steps, I took Morgan pre-1938 Morgan silver dollars, and they refused to take them.
Then the debt was discharged. If you tendered payment, why did they refuse them?
Because they said they had to have cash, Federal Reserve notes, or a cashier's check for that.
Give them a promissory note.
I did that. They still use the sheriff to kick me off the land. That's what they're doing with all of these foreclosures. They're coming in, right, wrong, or otherwise, and kicking everybody off the land. It's the sheriff. It's the sheriffs and the police, the cops, and everybody that should be receiving the tax bill for taking you off your land.
Yeah. Well, what you need to do is they did a taxable termination on you.
Yeah, they did.
You need to fill out a 1099 OID making the sheriff the recipient of the funds. Whoever foreclosed on the property, you need to make them pay the tax.
Yeah, that would be the sheriff and the judge.
The sheriff and the judge. I've shut them down every time doing this.
Okay. But now we've got somebody else in the property, and he won't get off the property.
Well, then the bank either they have to either give you the property back, do a writ of replevant.
Okay, against the guy that's in there?
What you have to do is do a motion for void judgment. You need to get rid of the void judgment. In California, section, I think it's 734 of the Code of Civil Procedure.
Mm-hmm.
You'd have to find the statute that deals with void judgments.
Yeah, but
file a motion for void judgment.
wouldn't it just be easier to send the sheriff and the judge the 1099 OID and the 8182 form? 82.
Yeah, but you got to get rid of the void judgment.
Right, but can you not tell them to correct the record and straighten?
Yeah, but first you have to get rid of the void judgment. You got a judgment that says they have a right to foreclose on the property. You got to get rid of that. That's why you should challenge these under the Fair Debt Collection Practices Act. And nobody's doing that.
Well, we have tried to do that in the previous, but we didn't have as detailed instructions as you're giving us now.
You need to challenge the fair. I've won every, and I'll show you. I've got some of the letters here. I'll show you. Does everybody understand this? And I'm willing to share these letters for you. Here's the 8281.
That's what we need to go over right now. That's really important.
Okay, well,
so the issuer's
let's go over it.
The issuer's name would be the borrower, right?
Yeah, let me whoop.
Gene. That is gross. Very, very bad.
Okay, 8281.
You just had it on the screen.
Yeah, okay, I got to pull it back up again. 8281. You can see I'm downloading it. You can you can just type it in on your search engine. Here it is.
All right.
And I'm gonna blow this up.
Okay.
So you can see it.
Let's go
Can
over
you see it?
line. Yes, I see it fine.
Okay, here's the OMB number.
And how do you find, okay, yeah, on that form, yeah, all right.
Issuer's name. You put your all capital letter name here. You need to write this down.
We are writing it.
Write it down. I go over this stuff, and then the next following week I'll give you a test, and I'll bet everybody can flunk it.
No. So.
You're the issuer.
Yes.
You put your all capital letter name here.
Right, and then the taxpayer ID number is with the dashes, right?
Right.
Okay.
That's line 2.
Okay.
Then you go to 1B. This is 1A, your name.
Okay, 1B, is that the address of the property or your current address?
Well, you put your address down where you're living.
Okay.
Then you put your city down. 1C is the city.
Right.
And state. Do not abbreviate it. Spell it out in lowercase letters.
Why
not uppercase.
Why lowercase there?
Country.
Where's country?
If you spell it in lowercase, like California is a territory of Mexico.
Yeah.
I don't put CA in there.
Okay.
I
And
can take you into a zip code directory put out by the IRS that'll tell you that CA is an abbreviation for a country. Did you know that?
no.
Do not use abbreviations.
Okay. How about the zip code?
You can put the zip code in there, but put it in brackets. That means it's not there.
Okay. Name of representative.
Okay, you go down, it says see instructions. It says here's you put your you got to read these instructions first.
Okay.
See, these are all public debt instruments. And you need to go in here. It says if you are, go ahead and read this. Purpose of the form. I want you to, this is how you learn.
If you are the issuer of publicly offered debt instruments having original issue discount, OID, file Form 8281 to provide the information required by Section 1275C.
Okay, write that down.
Okay.
You need to go into Title 26 and read 1275C. It says a note is a public debt instrument.
Okay. The reporting requirements of Section 1275C were designed to facilitate the IRS's collection and publication of the OID information needed by brokers and middlemen in order for them to provide information returns to holders of OID debt instruments. Since 1984, the IRS has compiled the OID information reported by the issuer on Form 8281 and made that information available to the public in the OID tables to publication 1212.
So?
Okay, so again.
Okay, so you, now read it. Go down and read this whole thing.
Read what? For each year a debt instrument is outstanding, the following information reported on Form 8281 will be published in the OID tables to publication 1212, which is available at www.irs.gov.
Let me ask you a question. If you build a model airplane, don't you read your instructions before you put it together?
Of course.
Well, you're not going to do it right then, are you?
If you don't, you might get the parts in the wrong area.
So what does it say here? It says, number one, you have to have the issuer's name.
The QSIP number, again.
You have to have the QSIP number, the issue date.
Go over getting QSIP numbers. You were supposed to put that in a handout, and you haven't given it out yet.
This is available on the IRS website.
The QSIP numbers?
Yeah, you can get the QSIP number.
How do you get the QSIP numbers?
It's on the B5 prospectus. Because when they sell these as mortgage-backed securities, they have to have the QSIP number.
Okay, so going in and researching Edgar Archives, the B5 prospectuses have been hard to get. We've had a couple of emails this week. I didn't get a chance to give them to you, of students that sent their information for you to look up the QSIP number. I have to get that to you probably tomorrow.
Okay, get it to me and I'll look up the QSIP number.
Okay, so that's what people are interested in.
Okay, the issue date was the date you signed it, which is closing.
Okay. Issue.
And if it's a 30-year note, the maturity date is the date at 30. If you had the loan in 2000, is in 2030. That's the maturity date.
Okay.
The issue price is the OID, original issue discount, which is the value of the security at closing.
Let's explain that a little bit more carefully now.
Okay, the issue price is
the
the price of the what they're doing, because it's an investment contract and you have a security. The issue price is the value of the mortgage at closing.
At closing. So in other words, the value of the promissory note.
Right. And it tells you in the deed of trust and the adjustable rate rider what the annual stated interest rate is.
Okay, in deed of trust. Okay. Now,
Then you have
and what is this variable contingent?
where are you at?
I'm on 9B and 9C on the OID form.
Well, you're jumping ahead. Let's finish this up.
No, because you were talking about stated interest rate in the deed of trust. And beside it, it's got a box that you check, variable or contingent.
Well, let's go back up here.
Right. Right there. Over to the right. Right there.
Yeah. This.
Yeah.
That would be your adjustable rate rider.
And if you don't have one of those?
Then it would be contingent. Almost all notes have adjustable rate rider or adjustable rate note.
Okay.
That's why the instrument goes up in value.
Okay, so, all right, we got those two things. Now we're back on 7 where it says type of instrument.
Well, see, and that's determined. So either it's a fixed mortgage or it's a variable.
Okay, so so it will say in the...
It will say that in your loan documents.
Okay.
You want to remember, you're dealing with an investment contract, not a mortgage loan.
Okay. All right. How about, so then the inflation indexed and contingent payment, where's that located? Where is that in the loan papers?
Well, that doesn't, only one of these is going to apply to you.
Okay, so 1 of 4.
It's either a fixed rate mortgage or a variable.
Okay.
These other two don't apply.
All right.
The issue price is the price of the...
Promissory.
So you got to think of this in terms of a public debt instrument.
Yeah, so that's the promissory note amount.
You're looking at this as a mortgage loan. That's why people don't think this way.
Okay.
They don't think like me.
Okay.
That's why I'm able to figure out what they're doing. The issue price is the principal amount, which is the value of the loan at closing.
Which is your promissory note.
Yeah.
Okay.
And then that's the value of the promissory note. You put that amount in there.
Yeah.
And then 9A, stated interest. See, instructions. Well, it tells you.
It's in the deed of trust.
It tells you that in the deed of trust what the stated interest is.
Okay. How about number 10, interest payment dates?
Well, it tells you when the interest payments are made. That's in your deed of trust, too.
Okay.
What we should do is I should go through one of these and fill it out.
Okay, but let's continue with just some of the rest of this, and then we'll come back and fill it out with an actual deed of trust.
What we need is a deed of trust, an actual deed of trust.
Okay. So
Okay.
what's the amount of the OID for the entire issue? The interest payments plus the promissory note amount?
Yeah.
Okay. And the yield to maturity, how do you figure that one out?
Well, what's the value of the...
Would that be the 30-year value?
Yeah. That's the value of the issue at maturity.
Okay.
So what you do is you multiply your if you go in the payment box, it tells you that the loan is not, if there's any default or any amount owed at closing, it can be paid at maturity.
Right.
Well, you want to remember it. You see, you guys keep forgetting that it's not in default
Until that 30-year mark.
Yeah, and number one, that's number one, and number two is it's not in foreclosure. It's not foreclosure property until they elect to treat it like that, and they can't do that.
Okay, and does that hold true for all your court orders too?
Yes.
So they can't really say you're in default and do an automatic garnishment if the maturity of that court document is not matured.
Right.
So
it says that right in the deed of trust that it's not in. How can it be in default if you can pay any any due amount that's owed at maturity? How can it be in default? Go read paragraph 3 of your deed of trust. Nobody reads anything.
So, and where would the counterpart of that be on a traffic ticket or a court order?
Well, you're on a traffic ticket. It's a bill.
Right.
So it's a public debt instrument.
But a lot of the traffic tickets, again, they don't have a figure on them.
Well, tell them you want a figure.
Okay. All right. So it said.
So what you'll do? Tell them you'll plead guilty to it if they put a dollar amount on there.
Okay.
Put a dollar amount on there, then you can OID it. They'll get rid of that case so fast it'll make your head swim.
Yeah.
Because it's a tax bill. Remember, it's a tax bill.
Correct. Okay, what about 13?
Stated redemption price at maturity of the entire issue. If the redemption price of each debt instrument within the issue is other than $1,000, indicate the stated redemption price of each debt instrument. Well, that's the value of the instrument at maturity. So multiply 30, if it's a 30-year note, multiply 30 times the amount of your monthly payments.
Okay. How about description of debt instrument?
Promissory note.
How about a court paper?
Same thing.
But there's no promissory note with a court paper, so would it be an order?
Yeah. If they put a dollar amount, tell them to put the amount on there.
Okay.
Make them send you a bill.
Yeah.
Tell them you want to pay off the entire indebtedness and to send you a bill.
Okay.
If they said they're not going to do it, say, then what are we doing here? If I don't owe anything, then you don't have. Do you have a claim against me? Ask him a question. Say, are you saying that I don't owe you anything, so therefore you're not going to bill me? If I don't owe you anything, then what are we doing here? Does that mean you don't have a claim against me? Ask him. Ask him a question. If he doesn't have a claim, then walk out of the courtroom.
Right. That's what I did with that judge when I said, you're making a claim on my estate. And he said, no, I'm not. She is, pointing to the prosecuting attorney.
Yeah, because he was in the hot seat. But do you know why he's in the hot seat when he does that?
Because he has to pay the taxes, and he hasn't done that.
Okay, why does he have to pay the tax?
Well, because he's getting the capital gains from whatever he signs.
Now, what have I been telling you?
But
why is he liable for the tax?
Because he's acting as a debt collector and he's not qualified?
No, he's acting as okay, who is the decedent in this case?
The estate.
Okay, and who acquired property from the decedent?
The court does when they do their orders.
So they're a qualified heir, aren't they?
Right. And because of that, they have to pay the taxes.
1014. Write this down. Section 1014 of Title 26. Write this stuff down. If I give you a test, you're all going to flunk it.
So what is 1014, a qualified heir?
It defines what a qualified heir is.
Yeah, that's what I thought.
And it's in 2032A. It defines what a qualified heir is. That's why they have to bring, you have to bring up the tax issue. And why they have an alternate valuation. See, there's an alternate valuation means there's 3 alternate valuations of an estate. And it all starts with the presumption of death. Remember, they've issued a presumptive death certificate on you. There's a presumption that that all capital letter name is dead.
Right.
And you can go in there, what does the dead man statute say? You cannot come into court and testify. Isn't the prosecutor or the district attorney or the county attorney testifying on behalf of the decedent?
Right, but they can't do that.
Well, you have to object to it or you waive it.
So in other words, your objection is to say, excuse me, but you're doing this alternative valuation on my estates, and that's a
He's in there testifying on behalf of a dead man. And
right.
tell him it's, under Rule 601, you got to go into your state evidence code. Incompetency, it goes to competency. A person cannot testify on behalf of a dead person. Is that all capital letter name, dead? Yes. Well, you can't go into court and testify on behalf of him. You can only give testimony on behalf of a live person, not a dead person.
Right.
And that's what the prosecutor, that's what the county attorney, the DA, the officer, you need to object. Grounds of the objection is incompetent, competency to testify. You cannot, under the dead man statutes, you cannot testify on behalf of a dead person.
Right. And that's why, but that was funny because I sat there, I told the judge, I says, you're dead, I'm alive. How dare you try to even talk to me? And he just looked at me and I said, I'm alive, I'm the beneficiary, and you're representing the dead thing. And he didn't say anything after that. And I said, well, I conditionally accept your silence upon proof of claim that you're not dead and that I'm not alive. And he just sat there muted. And we didn't go any further with that court hearing that day. And it was like my son said, I'm not the decedent, and I don't accept liability for the decedent. I'm the representative and the beneficiary of the decedent's estate.
Okay, isn't the United States bankrupt?
Of course.
Okay, isn't all bankrupt? And I've got Supreme Court decisions. I'll send them to you.
Okay, let me write that down on my list here. Supreme Court decisions, bankruptcy.
If you're bankrupt, if any company, association, or corporation is bankrupt, it's civilly dead. If it's civilly dead, it's legally dead.
And they can't do anything.
Yeah, they cannot come into court, a person that's dead. Let me ask you a question. Can you dig up a dead person and bring them into court to testify?
No. They might smell a little bit.
Well, that's what you're doing. When you let these people testify, you notice how the judge shut up when you said that?
Right. Yep, that's true. Okay, let's finish with this 8281 form. It says attach a schedule of OID per 1,000 principal amount for the life of the instrument. If the principal amount is other than $1,000, indicate the actual OID per principal amount per year. The schedule must...
Where are you at? You on page
15.
1?
Number 15.
Okay.
The schedule must be based on a 6-month accrual period. It must show the daily portion of OID for each actual period and the total OID for each calendar year. For additional requirements, see the instructions.
You need to read the instructions. What does accrual mean?
You got me on that one. I don't know.
Doesn't interest accrue to principal? Who's the principal?
The homeowner.
Okay. And doesn't interest accrue to that? And isn't the bill they're sending you for the use of your income, which is the principal, and they're spending the interest? So the interest accrues to the principal.
Okay,
and it must be returned by filing a tax return.
Okay, so how do you figure an answer to that section?
Well, it talks about a 6-month accrual period.
Well, let's take a $200,000 mortgage note just as an example.
Well, take the interest, the monthly interest, and figure it up for a 6-month period and multiply it times the principal. And that will give you the interest for the 6-month accrual period.
Say that one more time, a little slower.
Okay, it says it's a 6-month accrual period.
Right.
Okay, you have a stated monthly interest for each month. How much of the principal you're paying in interest?
Okay.
So that's in section 1. You want to read Title 26, section 163. Tells you what interest is.
Okay.
It's debt. You're paying, so they have to pay, so you have to figure, you multiply 6 times the amount of the interest. Figure out how much interest you're paying out each month and multiply it by 6.
So a person has to go get their deed of trust and it's all in the deed.
Right.
Okay. All right.
It says it must show the daily portion of the OID for each accrual period and the total OID for each calendar year. That's the 12 months.
Okay.
For additional requirements, see the instructions. So you need to go read the instructions. You got to read the instructions and then read the form.
Okay, but having read the instructions several times, that's
well, yeah, but we haven't gone through the instructions. We should be reading the instructions.
On 16.
Okay, it tells you who must file. You have to file it.
Okay.
Such as a bond, debenture, or note. Isn't a note a public debt instrument under 1275C?
Yes, it is.
Okay, so that's an original issue discount.
Right.
It's a publicly offered debt instrument.
Okay.
And aren't they offering these to the public as mortgage-backed securities?
Yes.
Okay, so they're publicly offered debt instruments.
Okay. So let's look at what section 15.
You should ask the judge. When he asks you, he wants you to pay a fine. Say, isn't that a public debt? Are you telling me that's a public debt instrument? Tell him you want to see the security agreement, the deposit agreement, and the escrow agreement for this publicly issued debt instrument. And you want to see the OID.
Okay, so you want to see, what was the 3 things?
Tell the judge you want to see the security agreement.
And what else?
Deposit agreement. and the escrow agreement. And you want the name of the broker that's brokering this.
Yeah, which is the judge.
The judge. And tell him tell him that you're making him a fiduciary trustee under the Uniform Trust Code.
Yeah, that's what really shut my case down, and they tried to deny that 3 times. And I came back and conditionally accepted it every time upon proof of claim that I could not appoint them under the 406, 407, and the power of
2038.
appointments.
Tell them that you're the donor and that you're the holder of the Power of Appointment Act of 1951, sections 2038, 2041, and 2514B of Title 26.
Well,
ask him a question. Say,
wait
can
a
you
minute,
prove?
Jane, back up a minute here so people can write. 2038, 2045, and what else?
No, 2041.
2041, and what else?
2514B of Title 26.
Okay.
Ask the judge a question. See, ask him, don't make statements because you're testifying. Ask questions.
Right.
You're not testifying if you're asking. Make him testify.
Right.
That's how you get him to testify.
That's what I did in my situation.
Loose lips sink battleships.
All right. So,
Ask him, say, do you have a claim against me? Tell him, say, I'm appointing you. I'm the holder. Ask him, say, can you prove that I'm not the donor? Do you have evidence on the court record that I'm not the donor and that I'm not the holder of the power of appointment?
does that apply to all court orders too?
Yes. Under 2038, 2041, and 2514B. Tell him, ask him if he has proof that you don't have that power. Ask him to prove that you're not the grantor, settler, and the donor of the estate of the decedent. Ask him if the executor has the power to appoint whoever he wants and the donor. Tell him to go read the Power of Appointment Act of 1951. It tells you that you have the power. You can revoke a trust. I have the power under 676 of Title 26. You can revoke the trust.
Okay. Let's get back to the form.
Tell him you're, as the donor with the power of appointment and the grantor settler, that you're revoking the constructive trust that he's created. You're revoking it. Watch the look on his face.
Uh-huh.
Uh-huh. You want to see his asshole pucker?
Well, yeah, that was kind of what I did. Not totally, but what I was heading to do. And then he finally just got up and said he was taking a recess. Okay, let's get back to this item 15 on this form so we can finish it and people can really understand where it is in the instructions.
Tell him you got a parachute, and you're going to give him a parachute so that when he jumps out the window, he doesn't kill himself.
And let's go back to this, section 15. We're going to make sure that we've got it right.
Okay, read it.
Attach a schedule of OID per 1,000 principal amount for the life of the instrument. If the principal amount is other than 1,000, indicate the actual OID per principal amount per year. So essentially, you take your 30-year note, which is 200,000, divide it by 30, which gives you a per year amount.
Yeah.
The schedule must be based on a 6-month accrual period. So then you divide that in half to get the 6 months. It must show the daily portion of OID for each accrual period and the total OID for each calendar year. So you take the 6 months, and that's the amount, and then you times it by 2 again to show that that's the amount for the year.
Yes.
Okay? So that's a payment divided by 30, divided by 2, and then times 2. Right?
Right.
Okay. So then we've got this figured out here. You take your $200,000 mortgage note, you divide it by 30, how much per year, then you divide that by 2 to get to the 6-month accrual period, and then they want to know for each calendar year, so then you're going to multiply it by 2 again to get the 12-month total year amount. And then we sign this in all capital letters or all upper and lowercase, and the title and the date. How do we sign this? With red ink again, first name.
Red ink. If you sign it blue ink, I'm gonna
red ink,
you.
But it's first name hyphen second name with a colon on each end. And then the title, what do you put for the title? Representative?
Yeah, authorized representative for the
Representative for the estate.
yeah. Put down executor. Put down donor, executor. Donor, grantor, settler, executor.
Okay. Settlor, that's OR. Donor, grantor, settlor, executor, and representative of the estate.
Right.
And then you sign your first name hyphen second name colon.
Right.
You don't, if you want to put family of, can you, or do you have to use your commercial charter?
I would just sign it with your regular signature.
No colon and no hyphens.
No. Just sign it in red ink, but like you do your regular signature.
Yeah, well, my signature now has just become Maria Janet, nothing else. Been that way now for about 4 or 5 years.
Okay, you use that, but you need to read before you fill this thing out.
Okay, let's go back on the instructions on this number 15 to show everybody where it's identified in the instructions on that particular section, so that our screenshot can get a screenshot of that section.
Now this tells you who must file. Read that.
We did that earlier. An issuer of a publicly offered debt instrument, obligation having OID, such as a bond, debenture, or note, must file Form 8281. Publicly offered debt instruments also may include, and gives you several different kinds.
Okay.
Do not use this form for the following: regular interests of a real estate mortgage investment conduit.
Remember, this doesn't involve a REMIC because they never transferred the funds to the REMIC.
Okay, so this has nothing to do with the REMIC.
So that means you know why they didn't do that? Because they're not the issuer. You are.
Okay. Or collateralized debt obligations, CDOs, or REMICs and issuers of CDOs.
That's what they are.
It says REMICs and issuers must file. And that's what we are as an issuer.
Yeah.
Okay, so let's see if we can get down to the part that talks about box 15.
Well, let's finish reading this. It says, read this here.
Okay, number 2, instruments on which OID is de minimis as defined in section 1270, I can't quite read that, 1273A3 and regulation sections 1.1273-1B.
Now the regulations are the code 26 CFR.
Okay.
So you guys, you want to go in there and read that?
26 CFRs, the regulations on OIDs.
Yes, the Treasury regulations governing Section 1273A3. That's why you got to know your tax law before you start filling these forms out.
Okay. What is that, 26 CFR? What else? What is it? What's the rest of it?
1.1273-1D. You want to go in there and look at these?
Well, I think that we can look them up.
Or you want to do that as a homework assignment?
That's a good homework assignment. We went over these Treasury regulations several times in previous webinars.
Yes.
Okay, so now who gets these forms? IRS gets the original. And does everybody that we're filing an 8281 on get a copy?
Yes.
Can you put more than one person? But you can't do this until you find the QSIP number.
Yeah, you need the QSIP number.
Okay.
Okay, you know what it says down there at number 7? It talks about strip bonds or strip coupons. That's what that coupon on the bottom of your utility bill is. It's the strip coupon.
Okay, so I need to jump back up on the form. I'm in a little confusion here because on 3A it says name of representative. Who's the representative? The borrower or the bank? Or the
Well, let's go down here. It says see instructions.
3A.
Here it is.
3A to 3F. Enter the name and address and telephone number of an official or representative of the issuing company who has personal knowledge of this offering and who can be contacted if additional information is needed. So that would be the homeowner again.
Yes.
And their address and phone number. Okay.
Aren't you the representative of the all capital letter name?
Right.
Who has personal knowledge of this offering and who can be contacted if additional information is needed.
Right. Okay. All right.
Okay, now go down to part 2. Enter the Committee on Uniform Security Identification Procedures. QSIP number assigned to the instrument.
Right, and that's what we have to have you look up for us because we have no way to look it up.
See, but see, they never sold these things. Remember, you're thinking that they transferred them. They never transferred them.
Okay.
So how can they sell them?
Let's see if there's any questions on this. It all applies to, it doesn't matter what credit issue or court issue you're involved in. They all apply to this. So,
But you need to read this whole instruction.
Listen to this one here, Gina, because it took me a while to get down to it, but just listen. I had a complaint filed against me. I assume it was filed. I'd never seen it. I took a notice I'd received and accepted it for value as well as put private bonds and made a commercial draft with the presentment with the charge, took these into the clerk of the court to settle and close the account and was told by the court attorney the state had made a mistake and my stolen property would be returned from the police who had assaulted me, then arrested me after stealing my property. After this particular court date in which I did not sign a reset, Have I done what I needed to settle and close the account?
Did they settle and close it?
Person asking the question, did they? Well, they came back and said that the state made a mistake and the property would be returned.
Well, you need to ask them that. Ask them if they settled and ask them if they filed the tax return.
Okay. So then you go back to the court and say, did you file a tax return? Where is it?
Remember what Alexander Bove said in the complete book of wills, estates, and trust? What did he say? You need to get this book. You can buy it on the internet.
Right.
Read it.
We just haven't had the opportunity to completely go, to get into all this. So let's remind everybody what he said so it can be on our transcript so people can study.
Here's what Alexander Bove, he's one of the top, he's not only an attorney, he's a professor at the University of Boston in Massachusetts. He said you can't have settlement and closure on the estate until there's an agreement between the beneficiaries and the trustee as to what taxes are owed, how much the tax is and who owes it. If you appoint the judge as a trustee, who owns the tax?
Well, the judge has to file the tax return.
Yeah, tell him that under 3-601 and 602 of the Uniform Probate Code, you want him to put up a bond to guarantee payment of the tax since he's bringing a claim against you. Ask him if he has a claim against you. If he says no, then he doesn't have to do that. See, this all goes to what Elvik has been saying, if they have a claim or not. If they don't have a claim, then what are you doing in court?
Right. Okay. Okay, so let's keep going back to this section 15. So that I think we got that. We got through it. We've gone over this form. I think it's pretty well filled out. But again, where's that section in the instructions, Gene, so we can put it on a screenshot? It has to do with section 15.
Okay, you want section 15.
Box 14. 15, you just skipped it. Go down. Oh, you just missed it. Go down. You bumped off of it. I just saw it briefly. It's at the top of the column.
On page 2?
Keep going down. It'll be in the right-hand column at the very top. I don't know what page it was.
Here it is.
Okay, there it is.
Here's box 15. It's on page 3.
Attach 2 copies of the schedule of OID per 1,000. Principal amount for the life of the instrument. However, if the principal amount is other than 1,000, indicate the actual OID per principal amount per year and specify the actual principal amount. The schedule must be based on a 6-month accrual period. It must show the daily portion of OID for each accrual period and the total OID for each calendar year. If you check box 9B, variable, or box 9C, contingent, explain how the interest rate will be determined. We got to go over that one. To compute the OID allocable to a short accrual period for a debt instrument, you may use any reasonable method. Indicate what method you used. Okay, so we have to have 2 copies of this. And again, where we figured out our formula, payment divided by 30 divided by 2 times 2, but it doesn't go far enough for this 9A, 9B, and 9C. Explain that a little bit.
Okay, you mean the 9B and the 9C?
Yeah.
Well, if it's a veritable, see, you go to, that's the type, you need to read your deed of trust.
So it's in the deed.
If it's an adjustable rate rider, it's a veritable rate.
So they'll give you the answers in the deed.
Right.
Those two boxes, which have to go in box 15.
A fixed rate means the interest doesn't change. It remains the same. An adjustable rate means it fluctuates.
Right, but that's all defined in your deed of trust under your riders.
Right.
Okay, so now we know on box 15, not only do you do the formula, if it's a fixed payment divided by 30 divided by 2 times 2, but to go in and define 9B and 9C in box 15, you have to go to your deed of trust and find out what kind of riders you have and how it's defined there. And then your answer, it says how indicate what method you use. You can say computed in deed of trust, rider such and such, right?
Right.
Okay. I think we're done with 8281 now.
Okay, I'm going to show you some of the letters that I've written. I'm going to give everybody copies of these.
Copies of what? Let me write it down.
Letters that I've written. Here's one. Remember the letter I did for Elvick?
Yes, but you didn't give it out yet. People are anxiously waiting.
I haven't given it out because I just found it this week.
Okay.
Okay, read that. Can you read that?
To whom it may concern, I am writing regarding my recent filings of 1040 and 1040X and accompanied 1099 OIDs as original discounts. I have recently discovered that their case and the decedent's case number CR 0343954 from the state of Ohio involves generation skipping taxes as taxable terminations, taxable transfers, taxable distributions, and direct skips under subsections 2511, 2603, 2612A, B, small a, B, C, 1, and large A, B of Title 26, in which the taxes have not been paid. These transfers are subject to a tax imposed by Chapter 11 or 12 of an interest in properties of the decedent, capital Roger Nelvin Murray Elvick, estate, and property acquired from the decedent under sections 1014, small a, b, c, as qualified heirs under sections 2032, big A, small e, 1, and 9, big A, B, C, and under subsection 11 of Title 26. The above taxpayers are required to post a bond in lieu of personal liability in such amount and for each period as may be required. The individuals involved in this evasion of taxes are employees of the state, capitalized, of Ohio, capitalized, under a OPERS, Ohio Public Employees Retirement System, and are using property direct, indirectly, tangible, intangible, real or personal from the decedent's estate, capital letters, to fund U.S. equities, private equities, global bonds, non-U.S. equities, and real estate or REITs, real estate investment trusts. The principals involved in this tax scheme are William Mason, Dan Carrasses, Thomas Green, Michael Peterson, Richard Marcus, and in league with the above are from Minnesota, John Sealing, Carol Cern, Joseph Evans, and William Walker, who are holding unreported capital and interest as frozen assets in SPVs, special purpose vehicles, and SPEs, special purpose entities, BREs, bankruptcy remote entities, facets, financial asset securities investment trusts, REMICs, real estate mortgage investment conduits, and REITs, real estate investment trusts. I am requesting that the agency of the IRS and its Special Task Force Division for Estate and Gift Taxes to prepare and file a 706 tax returns reflecting the generation skipping transfer taxes that are owned by the above-named individual taxpayers as taxable terminations, taxable distributions, and direct skips from the decedent's estate, as reported on the file 1040, 1040X, and 1099 OIDs. and other incidentals that were sent in. If you have any questions regarding this matter or need any further information, please contact me at the address below. Respectfully, Roger Nelson Murray Elvick. And this went to Sean E. Riddle, Parole Officer, Adult Parole Authority, Cleveland, Ohio.
You know what he did when he got this letter?
He sent Elvick home.
Yeah, he came out to the house and said, "I'm sending you home."
So this is what everybody does that has an incarceration problem, has been incarcerated, will be incarcerated, is looking at any kind of time or any kind of fine or fee. This is what they need to give to all the prosecuting attorneys, to any probation officers, et cetera, et cetera. Right?
That's right. This is a court case.
Right. But it doesn't matter. Can you not give this to the bank CEO and to the trustee trying to sell the property on the courthouse steps?
Sure.
And this way says, look, we know the gig's up. We got it. Here's your name on this letter. Here's everybody's name involved in this situation. All judges, all attorneys, all trustees on the courthouse steps, all sheriffs, everybody that has moved anybody off a property or has held anybody liable for any court case. This is it. Right?
This is it.
Okay, there you go, folks. Now you've got that. It's going to be on the screenshot on this webinar this week. Is there any other letter that we can go into?
Yeah, I got another one here.
Okay, I'll read the second one coming up. This is to Capital One, Attention Accounting. I am writing in regard to your recent online accounting services, which shows that you are posting payment but not crediting the funds to my account, and you have not returned the bills of exchange back to me. Would that be a promissory note back to me instead of a bill of exchange?
Well, the bill itself is a bill of exchange.
Oh, okay.
If you convert it to a money order, it's a bill of exchange.
Okay. Since this is a prepaid account and exempt from levy, you are therefore in commercial dishonor for non-acceptance and payment under Sections 3, 505, 510 of the UCC, and are subject to forfeiture and collection under GAAP, Generally Accepted Accounting Principles. I want these payments posted in the amount of $6,000 for December 15th, $6,500 for December 17th, or in the alternative, send me the 1096 or 1098 tax returns. Wait a minute, I lost my screen. Hold on just a minute. Tax returns for, my little blue thing is in the way here. Give me just 10 seconds for this to get off my screen, because my screen goes into sleep mode. 1099 tax returns, for this account, along with the 1099 OID and 1099 INT forms, which will show who the payer and recipient of my funds are. Since you are the trustee and fiduciary of my account under pooling and servicing agreement, I want the credit card trust account and the name of the trust and the name of the indenture trustee who is handling and paying the interest on the certified securities to the DTC relative to the account. Now, instead of a credit card trust, would that be a mortgage trust?
Yes.
I also want a certified copy of the application determining the eligibility of the trustee to act under subsection A of Section 310 of the Trust Indenture Act in accordance with the rules and regulations prescribed by the Commission under Section 305 small b 2 of the Trust Indenture Act. I also want certified copies of the N-SA, capital letters, registration filed pursuant to Sections 8, small a, of the Investment Company Act of 1940, the 10-K annual report, the S3 registration statement, and S4, the prospectus filed pursuant to Rule 424B5 with the Securities Exchange Commission under Section 13 and 15 small d of the Securities Exchange Act of 1934. As the owner, principal, and creditor, I'm giving you 30 days to post the funds to my account, or comply with my demands relative to the above forms. Very sincerely, authorized representative. Okay, so this is what you use back again to your mortgage company CEO, to the trustee that's going to sell your house on the steps, to the sheriff that's going to be there to sell your house, and to the judge that's going to try and do an unlawful detainer. This would also go to the judge and the trustees in a bankruptcy court. So here's your information in a concise manner, summary manner of what you can do, folks. These screenshots will be on this week's webinar. Anything else that you want me to read, Gene?
Yeah, I've got another one here.
What is Nelson Reed? This is an attorney group.
Yeah,
okay.
This is a foreclosure case.
Right. I am writing in response to your recent admonition regarding my purported notice of rescission dated 30 August 2006 as being patently ludicrous. First of all, if you had bothered to read 15 U.S.C. section 1635, you would have found out that under section 1635 E1, small e1, and section 1635 small f does not apply to a residential mortgage transaction as that term is defined in section 1602W of Title 15. Secondly,
Kate, do you know why those sections do not apply?
Explain.
Well, because you're dealing in credit. They can't loan credit in a mortgage loan.
That's right. Banks are forbidden to loan credit.
Okay.
Second,
go ahead and read.
Section 1635 small e of Title 15 only applies to credit transactions, which is the reason mortgage transactions are exempted from its provisions. Thirdly, both you and your client, Bank 1NA, have maintained in your pleadings that you loaned me money, not credit, so why are you quoting Section 1635 of pleadings that you loaned Title 15, quoting 1635 of Title 15 when it only applies to credit transactions? They say that confession is good for the soul. Are you finally admitting that your client, Bank 1, is loaning credit as the money of account and not money of exchange? That appears to be the case since the law that you are quoting only applies to credit transactions. All unconscionable contracts are subject to rescission under the common law for failure to make the proper disclosures to constitute an acceptance. Where there is no meeting of the minds, there is no contract as required by sections 226.23 small b1 regarding notice of right to rescind is set forth in Ray Pearl, P-E-A-R-L, Maxwell versus Fairbanks Capital Corporation, 281 BR 101 and 202 Banker Lexus Bankruptcy Lexus 759. The UCC addresses unconscionably in sections 2-302. Since your client Bank 1NA did not make the proper disclosures regarding notice of rescission as set forth in Regulation Z, sections 226.23, small a, consumer's right to rescission, small b1, the transaction is subject to the provisions of 226.23 H, small h, special rules for foreclosures, hyphen 1, right to rescind. After the initiation of foreclosure on the consumer's principal dwelling that secures the credit obligations, the consumer shall have the right to rescind the transactions if small ii, the creditor did not provide the properly completed appropriate form in Appendix H of this part or substantially similar notice of rescission. Pull it up a little bit, Gene. In regard, let me see. In regard to your vapor theory, the U.S.
Wait a minute.
Go down. In regard to your vapor theory, the U.S. District Bankruptcy Court in re Maxwell 281 BR. Wait a minute. I lost it. There we go. At 101, pages 19 of 37, ruled in 2002. Nevertheless, Fairbanks, in a shocking display of corporate irresponsibility, repeatedly fabricated the amount of the debtor's obligation to it set out of thin air. What do you know here is a U.S. District Bankruptcy Court espousing the vapor theory or out of thin air theory. Obviously, this is a patently ludicrous assertion or opinion by the court, right? I think we have to go to page 2. You got to get me up to the top of page 2.
Okay.
Now, I can't read it. It's off my screen. You got to make it one page. Because I can't read on the right side. Let me see if I can hide the control panel. Hold on a minute. Okay, there we go. Now I can read it. Worthy of note is the fact that under Title 12, Section 24, Paragraph 7, national associations are only allowed or permitted to loan money and not credit. This prohibition started with the National Bank Act or Currency Act of June 3, 1864. And this is a screenshot, so we're going to be able to pull this down a little bit so our screenshot can get the bottom of the page too. And I won't go into the corporate powers of association. That's under Title 12, Subchapter Section 1, Section 24. So pull it up and let our screenshot get the bottom of the page, Gene. There we go. We should have gotten both sections of the page. Let's go on to page 3. Here and after in the sentence, this again is your, these are all the acts that you've put into your, all of the laws that you're putting into this letter, right?
Yeah. This is the National Bank Act, which is where Title 12 came from.
All right, pull it down.
This is the original law.
Pull it down so our screenshot can get the bottom of the page 2, which is page 3 now. We're at the bottom of page 3.
Can you see it now?
I'm not sure if I'm at the very bottom of the page.
Okay, this is 2 over here.
Yeah, we did 2. We got the screenshot of 2. Now we want to go page 3 down further.
This is 3 over here.
Right. Go down to the bottom of page 3.
All right, there you are.
Nope, you got to pull it up. We're not seeing the bottom of the page. There you go. There's our screenshot on the bottom of page 3. And page 4, how many pages does this go with the acts? So I'm going to say send me this letter to, what was the name of this letter? To who?
Nelson Reed.
Nelson Reed.
Right down there. This is the chief legal counsel. This is a 5,000 attorney law firm. I wrote this letter to them. They never responded to it.
Did they stop the foreclosure?
Yes.
Okay, so now we know it's Nelson Reed. How many pages is it to go up and down so our screenshot can get it?
Well, let me go through some of this stuff. You don't have to read all the laws, but it goes into, this is section 582 of Title 12 over here. This is page 5.
Okay.
And then,
here's some more. Since you're on paragraph 2, since your client Bank 1 NA cannot use its own capital, stock, or assets for the loan of money, where did your client Bank 1 NA get the security and collateral for the alleged loan of money? Nowhere is the word credit used in any of the above provisions. So by what authority of law are you quoting 15 U.S.C. section 1635 under the truth in lending when it only applies to credit transactions? Since the alleged promissory note and security agreement do not state that your client, Bank 1NA, is loaning credit or that I have received credit as the bargain for consideration, what consideration and in what form and substance did your client, Bank 1, give in exchange for the alleged promissory note and security agreement? The problem with your vapor theory is that you do not understand the difference between money of exchange, which is lawful money, and money of account. So I'm going to spell it out in plain English. When Congress passed H.J.R. 192 on June 5, 1933, it was against public policy for a contract to contain a clause which purports to give the obligee the right to demand payment in any kind of specie, coin, or currency of the United States. Title 12, Section 152 stated that the lawful money of the United States shall be construed to be gold and silver coin. Your statements regarding accounting are patently ludicrous, as aptly shown by Statement of Financial Accounting, Statement number 95, page 63, footnote number 1, which states, you got to pull it down, Gene. I can't read the bottom of the page.
Can you read it now?
Now you got to pull it up a little bit. Pull it up some more. Okay, all charges and credits to those deposit accounts are cash receipts or payments to both the entity owning the account and the bank holding it. For example, a bank's granting of a loan by crediting the proceeds to a customer's demand deposit account is a cash payment by the bank and a cash receipt of the customer when the entry is made. This plainly shows that when a check, draft, bill of exchange, or promissory note is deposited in an account, it is not only a cash payment and cash receipt, but is the equivalent of money and is so stated in Title 12, Section 1813, Big L, 1, to wit. You got to go up to the top of 6.
Okay, there it is.
No, we're not up there. We see the bottom of 6. There we go. The term deposit. The unpaid balance of money or its equivalent received or held by a bank or savings association in the usual course of business and for which it has given or is obligated to give credit, either conditionally or unconditionally, to a commercial, checking, savings, time, or thrift account, or which is evidenced by its certificate of deposit, thrift certificate, investment certificate, certificate of indebtedness, or other similar name, or a check or draft drawn against the deposit account and certified by the bank or savings association, or a letter of credit or a traveler's check on which the bank or savings association is primarily liable, provided that without limiting the generality of the term money or its equivalent, any such account or an instrument must be regarded as evidencing the receipt of the equivalent of money when credited or issued in exchange for checks or drafts or for a promissory note upon which the person obtaining any such credit or instrument is primarily or secondarily liable, or for a charge against the deposit account, or in settlement of checks, drafts, or other instruments forwarded to such bank or savings association for collection. And then you go into more laws and rules here.
This is Barron's dictionary. Read that. That's very important.
Which one? Credit banking.
Barron's.
Credit banking is defined in Barron's Dictionary of Banking Terms, 3rd edition by Thomas Fitch, as 3. Bookkeeping, entry representing a deposit of funds into an account. In accounting, a credit entry notes as increase in liabilities, owner's equity, and revenues, and a decrease in assets and expenses. This confirms that the depositor and drawmakers is the issuer and originator of the first funds transfer, as stated in Section 1304.51, parentheses AO, parentheses 11 of Title 13 of the ORC, Sections 4A-104C of the UCC, and makes the depositor the principal or creditor in the transaction. Since Bank 1 never lent any of its own pre-existing money, credit, or assets as consideration to purchase the note or credit agreement, Robertson's notes When a bank does the foregoing, then in that event there is utter failure of consideration for the loan contract. You want me to keep going on that?
Yeah, read this.
Pull it up a little bit. Some more. There we go. As the promissory note, which is both the subject and object of the current foreclosure action, is a non-negotiable instrument due to the fact that the note itself is subject to the security agreement, mortgage, and trustee, which makes the note a conditional promise to pay and takes it out of the category of a negotiable instrument under Article 3, Section 3-104 of the UCC, and Title 13, Section 1303.03, Big A, 1, 2, 3 of the ORC. A mortgage is not a negotiable instrument because it does not create an unconditional promise to pay money, but merely creates a security interest in real estate, secure the payment of debt. Mox versus Jordan, 1990, 186 Michigan, appellant, page 42, and 463 Northwest 2nd, page 114, 13 U.S. UCCRS, 2nd, page 770. All promissory notes are presumed to be securities under the, I've lost my screen again, under the Howey test, Howey test, unless evidence is presented to rebut the presumption. All promissory notes are securities under Title 17, Section 1707.01, Big B, 10 of the Ohio Revised Code. The term security means any note, stock, treasury, stock, security, future bond, debenture, certificate of interest, or participation in any profit-sharing agreement or in any oil, gas, or other mineral royalty or lease, any collateral trust certificate, pre-organization certificate, or subscription, transferable share, investment contract, voting trust certificate, certificate of deposit for security, any put, call, straddle, option, or privilege on any security, certificate of deposit, or group of index securities, including any interest thereon or based on the value thereof, or any put, call, straddle, option, or privilege entered into on a national securities exchange relating to foreign currency, or in general any instrument commonly known as a certificate, or any certificate of interest or participation in temporary or interim certificate for, receipt for, or warrant or right to subscribe to or purchase any of the foregoing, but shall not include currency or any note, draft, bill of exchange, or banker's acceptance which has a maturity at the time of issuance of not exceeding 9 months, exclusive of days of grace or any renewal thereof, the maturity of which is likewise limited. Title 15, Section 78, small c, 10, subsection 10. So then that's what we've been talking about with all this.
You know, it's excluded. Notice it says all securities means any note, doesn't it?
That does not have a 9-month maturity date is excluded.
It's excluded. But it doesn't include any note that has a maturity of 9 months or less.
Right.
So so to be a note, it has to have a maturity of 9 months or less.
To be excluded.
No, to be a note.
Right. If it's a note, it's 9 months or less. If it's more than 9 months, it's a security.
Right. And so if it's a note, it's excluded from the definition of a security.
Right.
So it can't be both a note and a security. It has to be one or the other.
Okay.
Okay, now read the next paragraph. It tells you the test they use.
We conclude then that in determining whether an instrument denominated a note is a security, courts are to apply the version of the family resemblance test that we have articulated here. A note is presumed to be a security and that presumption may be rebutted only by showing that the note bears a strong resemblance in terms of the four factors we have identified to one of the enumerated categories of the instrument. If an instrument is not sufficiently similar to an item on the list, the decision whether another category should be added is to be made by examining the same factors. Reeves versus Ernst & Young, 494 U.S. 56, 1990. Securities and Exchange Commission versus W.J. Howey, Howey, Company, 328 U.S. 293, 1946. And Perrysburg Township, TWP, versus Rossford, 103 Ohio State, 3rd edition, 79, 2004. Ohio Supreme Court, 4362, following the Reeves and Howey cases cited above. So these are all the rules and regulations that tell you all of that.
Now read the next paragraph. It tells you what elements are in an investment contract.
The three elements for establishing an investment contract are: 1, an investment of money; 2, in a common enterprise; 3, with profits to come solely from the efforts of others. That's at 301, let's go 66 Supreme Court at 1104. Steinhardt, Steinhardt, Group Incorporated versus Citicorp, 126 Fed 3rd, 144. That's the Third Circuit, 1997.
Go ahead and read it. Read the next paragraph.
The economic reality of the promissory note and the security agreement is that they are in substance an investment contract and a commercial transaction in form only as they contain all elements of the family resemblance test as outlined in Reeves versus Ernst & Young and in SEC versus Howey. Okay, this document's going to be provided to everybody, Gene?
Yeah, well, go ahead and finish reading. You only got 2 more pages.
Oh, really? Okay.
Yeah, this is 17 pages, but I want you to, you should study this because this tells you why it's a security.
This is the one thing that you take into court. You tear this apart. You make your discovery questions. You make your questions back to whomever you're going against, whether it's a trustee on the steps of the courthouse, whether it's the sheriff, the judge, prosecuting attorneys, the regular attorneys, whoever. It all applies to the same thing. In some cases, proving that the documents were securities might be done by proving the document itself, which on its face would be a note, a bond, or a share of stock. Nor does Foreman require a different result. Respondents are correct that in Foreman, we eschewed a literal approach that would invoke the Act's coverage simply because the instrument carried the label stock.
You didn't read this. You jumped down to read this right here. In contrast.
In contrast, the 8th and District of Columbia circuits apply the tests we created in SEC versus W.J. Howey to determine whether an instrument is an investment contract to the determination whether an instrument is a note. Under this test, a note is a security only if it evidences 1, an investment; 2, in a common enterprise; 3, with a reasonable expectation of profits; 4, to be derived from the entrepreneurial or managerial efforts of others. And again, case law.
Do you have all that in your loan transactions? Sure you do.
Well, and don't you have that all in the courtroom setting also?
Yeah. This is what's going on in the court.
See, this is what you ask them for. Provide the elements of the investment contract of order number so-and-so, right?
Yeah.
Okay.
Finish reading this paragraph here, this page, the whole page.
What do you mean, at the bottom of, or the top?
Well, Go to page. I think this is page 8. Over here. Can you see this?
Yeah. Okay, the note involved in this case is non-negotiable, is a security, has the maturity date of more than 9 months, as stated in Title 15, Section 78C10, and therefore does not fall in the category of an exception and is a security with a 12-month maturity date stated in the index at Big B, page 2 of 4 of the promissory note/security, and is subject to the U.S. Treasury Securities ARM adjustable rate mortgage index that is transferable at page 1 of 4 in first paragraph of promissory note. Also, your client's promissory note security and security agreement cannot pass the traditional family resemblance or the economical reality test. When a note does not bear a strong family resemblance to these examples, note secured by a mortgage on a home and has a maturity exceeding 9 months, as your note does, Section 10B of the 1934 Act should generally be held to apply. Quoted at page 1138 of case, the Exchange National Bank of Chicago versus Tucci, Touche, Ross and Company, 544 Fed 2nd, 1126, 1976. The above is further validated by the fact that the mortgage payments on the alleged loan as principal and interest go to the BIH's beneficial interest holders as pass-through claims on the cash flow paid out as interest and dividends to equity or direct participants by the indenture trustee as outlined in your client's S3A, S-3/A registration statement and Rule 424B5 prospectus filed at closing by your client Bank 1 with the Securities Exchange Commission under Rule 12G of SEC Act of 1934. In the Securities Act, the term security was defined to include by name or description many documents in which they are common trading for speculation or investment. Some such as notes, bonds, and stocks are pretty much standardized, and the name alone carries well-settled meaning. Others are of more variable character and were necessarily designated by more descriptive terms, such as transferable share, investment contract, and in general, any interest or instrument commonly known as a security. We cannot read out of the statute those general descriptive designations merely because more specific ones have been used to reach some kinds of documents. Instruments may be included within any of these definitions as a matter of law. I lost my screen. Hold on a minute.
Right here.
Or if on their face they answer to the name or description. However, the reach of the act does not stop the obvious and commonplace. I don't know. I mean, that's covered up. What's this word, Jean? They're novel, uncommon, or irregular devices, whatever they appear to be, are also reached if it proved as a matter of fact that they were widely offered or dealt in under terms or courses of dealing which establish their character in commerce as investment contracts, or as any interest or instrument commonly known as a security. The proof here seems clear that these defendants' offers brought their instruments within these terms. 320 U.S. 344 and 352. Securities and Exchange Commission versus CM Joyner Leasing Corp. 320 U.S. 344, 1943. Contrary to respondent's implication, the court has never foreclosed the possibility that stock would be found to be a security simply because it is what it purports to be. And that's the Joyner case. We do nothing in the words of the Act. We merely accept them. Let's go down to some of these are all court cases that are in the document.
Okay, let's go down. These are all your definitions of...
Right. Our students are looking for the way that you finalize and bring in the statements against Bank One. The chapters and the titles, they're all their language there, and it's,
Here's the Enron case, and you'll find out. Just read this one paragraph here.
Which one?
Over here.
Disguised loans.
Yeah.
Okay. Another tactic utilized by Enron and its banks to falsify Enron's financial condition and hide debt involved manipulative and deceptive transactions with J.P. Morgan, Citigroup, and CS First Boston. J.P. Morgan used an entity it controlled known as Mahonia, located in the Channel Islands off England. J.P. Morgan and Enron utilized a scheme which J.P. Morgan had utilized before with a commodities trader from Sumitomo, by which large bank loans were disguised as commodity trades. In fact, offsetting trades were arranged with the ultimate cost differential being in favor of the bank, representing the interest rate on the disguised loan. By utilizing this manipulative or deceptive device, J.P. Morgan and Enron falsifies Enron's financial condition, concealing some $4 billion in debt. Paragraph 44.14. Citigroup and CS First Boston engaged in similar subterfuges to disguise large loans to Enron. Citigroup lent Enron $2.4 billion via prepaid swaps, the so-called Delta transactions conducted through Citigroup's Cayman Islands subsidiary. These swap transactions perfectly replicated loans and were in fact loans, but Enron never reported them as such on its balance sheet. CS First Boston also engaged in making disguised loans to Enron. CS First Boston gave Enron $150 million to be repaid over 2 years, with Enron's payments to vary with the price of the oil. The transaction was made to appear to be a swap, but was in fact a loan, a reality admitted by the bank. It was like a floating rate loan, said Penn Pendleton, a CS First Boston spokesman. We booked the transaction as a loan. However, Enron did not show the loans on its balance sheet.
Now read the next paragraph.
By so doing, J.P. Morgan, Citigroup, and CS First Boston were able to secretly prop up Enron's deteriorating finances without disclosing that in fact Enron had borrowed between $4 to $6 billion from those banks. Also astonishing about the Mahonia and Delta transactions is the way J.P. Morgan and Citigroup were paid off to engage in this subterfuge, based on Enron's purported investment-grade credit rating. Enron could have borrowed money from banks at 3.75 to 4.25%. However, in the phony Mahonia and Delta transaction, Enron paid J.P. Morgan and Citigroup between 6.5 and 7% for the disguised loan, a huge difference from the cost of a legitimate bank loan, which made these disguised loans hugely profitable for J.P. Morgan and Citigroup, in effect paying them off for participating in these bogus transactions.
In other words, what they were doing, what Enron was doing, was disguising investment contracts as mortgage loans. What banks are doing today is disguising mortgage loans as investment contracts.
Right. Let's see if there's any questions on the board. What if your estate allows them to take your home in lieu of a monetary amount?
They can't do that unless they declare it to be foreclosure property by filing a tax return.
And they have to do the exemption and they have to do the tax return before they can get the
They have to transfer the funds before they can even have a REMIC.
Before they
get the tax exemption.
They can't apply for that exemption, can they?
No, they can't. And so what they're doing is billing you for their tax that they owed because they didn't transfer the funds to the REMIC.
Right. Jean mentioned
that's the whole thing in a nutshell.
That there are other cases involved besides guaranteed trust and Headwood. What other cases?
Well, there's a whole bunch of them in here.
Well, you got to tell us, and then you got to give us some of those cases.
Well, they're all in here.
Okay, so that's under the cases that he's going to give.
I'll give you this. I'm going to send this to you.
Okay, you didn't do it for 2 weeks, so now we're going to put you on the spot, and you got to give it to us.
Okay.
Okay, Jean, in your opinion, how strong is the argument that the loan is not in default as it has not reached the maturity date?
That's very strong.
Okay. Lloyd Smith has been teaching this for 20 years.
It's not in default for two reasons. The money was never transferred to REMIC to create a default. That's number one. And they never elected to treat the property as foreclosure property. So it's not in default.
Right. Okay.
Not.
So they use mafia thugs to take you out of your house.
Read the last paragraph, and then we'll close.
Which pair? Okay, let me hide the screen because we're going to come back to the questions. In light of the above, it brings to remembrance Luke 11:46-52. Jesus answered, "Woe unto you lawyers also. You lay impossible burdens on men, but will not lift a finger to lighten them. Woe unto you. You build the tombs of the prophets, but it was your fathers who murdered them. You show that you stand behind the deeds of your fathers. They committed the murders, and you erect the tombs. That is why the wisdom of God has said, I will send them prophets and apostles, and some of these they will persecute and kill, so that this generation will have to account for the blood of all the prophets shed since the foundation of the world. Their guilt stretches from the blood of Abel to the blood of Zechariah, who met his death between the altar and the sanctuary. Yes, I will tell you, this generation will have to account for it. Woe unto you lawyers! You have taken away the key of knowledge. You yourselves have not gained access, yet you have stopped those who wish to enter. The wrath of God is being revealed from heaven against all of the irreligious and perverse spirit of men who in this perversity of theirs hinder the truth." Romans 1:18. Let's go back for some final questions here. Let's see where was I? How do we properly do promissory notes?
I'll give you an example.
Okay.
I've got one on my computer. I'll send it out along with these letters.
Promissory note.
That was accepted.
Okay.
They accepted it.
Okay. When in court, would carrying 21 or more silver dollars showing that you are not bankrupt be of any use?
No, because they don't use gold and silver is no longer money. It's a commodity. That's why they refused your tender of gold and silver, because gold and silver is no longer money. It's a commodity, not money.
Okay, people are asking here, have you got the letter rogatory template ready for us yet? I know that you said you were still working on it today.
Yeah, I'm still working on it, yeah.
Okay, as soon as he gets it finished, he will let me know.
I'll let you know.
Now, all of these issues would go away if we paid them with a promissory note. Is that?
Yes.
Okay.
I'll show you how to do a promissory
proper
note.
Promissory note.
We'll go over that next week.
Okay, the 8281, how does it apply to tickets or judgments? We went over that earlier. You just have to listen to the transcript of this recording again. How it applies to the offers of the court.
All debt instruments, all commercial paper is debt instruments.
And that includes all orders of a court, any traffic case or whatever.
Yeah, if you endorse it, you're the drawer and the maker, and you're issuing the original debt obligation.
Is the case
public
number,
debt instrument.
Is the case number the QSIP number on a court case?
Yes, I'll get all that.
Okay, we have someone here that said you promised a QSIP number 2 months ago and haven't given it.
You got to send me. You got to give me a particular key. I'll show you where to get the
QSIP. Resend it to me. They're going to a sale on Wednesday. What we went over tonight and what you can put in, even without all of the laws attached on the screenshots. What I read tonight, what you can do tonight, is what needs to go into your letter rogatory. Mine was simple, 2 paragraphs. I said, I'm not the decedent. Prove that I conditionally accept your offer to sell my property on the steps of the courthouse upon proof of claim that I am the decedent, that I have accepted liability for the decedent, and that you are not liable for the taxes. I, as representative of the decedent's estate. Okay, one here. if it's not a mortgage in a court complaint. We went all over that. You guys are not listening.
It's an investment contract.
Okay? What if they don't send you a bill? Then you do the OID, or you give them a 99A and a 99C.
Yeah.
You know?
Cancellation. We'll go over that next week.
Okay, here's one here. Final notice of intent to levy says I owe $204,000. Is this a bill? Yes, it is.
Yes.
And
yes.
you can take that and put the money order on it and do the 96, the 81, 82, 81, the 1096.
And that's 1040V.
And the 1040V. Tax sale certificates are recorded as a mortgage in County of Bergen County Clerk. If these are mortgaged, then the township must have an interest in the land sold at the sale to the U.S. Bank. Does the township give a mortgage to the tax purchaser? Can you show me step by step what to do with this using what we've been taught about foreclosures? Your tax certificate is the same as a court order in judgment, as a mortgage. You're not listening. You must take these transcripts very slowly and learn how to put them together in your conditional acceptances for anybody that's coming against you. Right, Gene?
Right.
Let me see. Somebody needs the dead man statute. Google it. It will come right up.
It's in 601. Go read the Federal Rules of Evidence, Rule 601. Just type in that competency to testify. That's where they put the dead man statutes.
Under 601 of Title 26.
No, 601 of the Federal Rules of Evidence.
Oh, Federal Rules of Evidence, excuse me, Section 601. And that's under the competency test.
Right. That's where they put it. They're incompetent because they're testifying on behalf of a dead person. So object to it. Okay. It doesn't matter whether they ignore you or not. You got to raise the objection. Otherwise, you waived it.
Right. Face of dead instruments that are not publicly offered. So when you fail to request the receipt for the transaction, you have abandoned the claim. And when the borrower does the first payment, the decedent is now cured the default from the closing of escrow. Yes or no?
Yes.
Yes. Okay. So I tell this agent that he has no right to testify against a dead person.
Tell him that under public policy he's civilly dead and bankrupt.
Okay.
He's an insolvent debtor.
And that would be the attorney, or who would that be? The judge?
Yeah, it'd be the attorney, yeah.
And the judge. In a federal criminal case, is there a statute of limitations in regards to raising the dead man statute?
Well, if you don't raise it, you waive it. So there is. If you don't object, you waive the objection under the rules of evidence. That's why you got to know the rules of evidence. You should be asking for the loan application, not the note. Make them produce the loan application.
Okay, when you're filling out 8281, you just sign it in red. You don't need to fill it all out in red, do you?
No.
Okay. Oh, here's one. Will we get a copy of the rogatory letter and conditional acceptance letter?
Yes.
Okay. Do we only
I gave you that last week.
There is no statute of limitations on your mortgages, folks, because it's under fraud. There is no statute of limitations. Again, signing it under your name, you just sign your, I think on the thing you said, just your regular signature as on this question board. Yes, it can be that.
Yes.
Is there a way that we can find out if they've paid the taxes? They never do.
Yeah, ask them for the tax return and the statement.
Can you do electronic OID filings? I don't think so because it's in triplicate.
No, you have to file them in original.
Okay. Oh, some of these questions are coming back and forth about 4 times.
Maybe you ought to read all this stuff. I'll send you all the stuff. If you got questions, maybe we should go into this before we start the class so that everybody gets their questions
We've
answered.
had a couple of statements on that. It would be nice to go into some of the questions first, but setting a time limit of like 15 minutes.
Yeah.
So they're saying, how about state taxes?
They're predicated on the federal. Same thing. It's all federal. There is no state taxes.
What about an IRS agent whose final notice of intent to levy? It's the same thing. What is meant by online accounting?
Well, it's the statement online, the accounting statement of accounting online.
How do you do a void judgment on a foreclosure?
Go into this, in California, it's in the Code of Civil Procedure. All states have a void judgment statute. Just type it in. Revised statutes of whatever your state is and ask the void judgment statute. It'll tell you what it is.
Title 18, Part 1, Chapter 25, Sections 479, 483, and Title 18, Part 1, Chapter 42, Section 42, 892, and 894. If you have the FACNMWHFIT material.
So if it's not, if you could void the judgment, then it's not valid. None of these judgments are valid. But you got to learn this stuff so you can put it together.
Right, so that you can defend it.
So you can defend it.
Now, and you would also include a 4490 to the bank or the judge or the sheriff on the steps of the courthouse, because they're all liable.
Right, and the 3949A.
Right. So
and the 8300. Don't forget the 8300 cash transaction.
Okay, and you give that to them even though you have not tendered it to IRS?
Yes.
And as giving them an idea that you know what it is, and
make them file it. Tell the judge you want him to file these forms. You got to write all this stuff down so you get it. Otherwise, if you leave something out, then you're not making the judge. You got to show the judge that you know what you're doing.
Yeah.
If you're the executor of the state, you need to run it.
Oh, we have someone here that said, Jane, you didn't give us a good UCC1 yet. So you were supposed to do that 2 weeks ago.
Well, you'll get it.
Okay. That's about, I don't see these questions are just repeating over and over and over again. We're at the end of it. And we're at the end of tonight's show, Jean. So I'm going to say thank you to everybody. We will be back next week. We will get these letters out to you. Hopefully, Jean will send them right over to me tonight or tomorrow morning. And they should be ready with the screenshots on the recordings and the screenshot document files that go out with the recordings. Jean, closing words.
I love you all. Read Zero Limits. Read Zero Limits. I love you, dear memories. I forgive you, dear memories. I am grateful, dear memories. I'm sorry for you, dear memories. Those 4 things. You need to repeat those 20 times a day. Watch what happens, how everything changes.
That really does work, and I use that every day.
You're cleaning out the memory. Clean out your memory, and you'll get rid of all this negative.
Right, that's true. And folks,
And don't send money to Maria. Send it to me. You all have my address and my email for the Pacer account or PayPal account. It's manowskitom@yahoo.com. Make payments to the PayPal account.
and make sure that when you make a payment, you notify Maria that you have made the payment with verification so that you get approved for the call. We had 7 people tonight that did not demonstrate verification of their payments. I couldn't validate a payment, and so 7 people did not get on our show tonight. We want everybody to be here and everybody to take advantage of this information. So make sure you make the payments to manowskitom@yahoo.com and send Maria verification of that payment. No matter how you get it, make sure I get verification of the payments under Kenix@gmail. It's all in the informational file that you all get. With that, thank you so much for everybody, and we're